Feel free to start when you're ready.
Okay, so today we're going to triple attack this, but start with Jordy. Susanna and I are going to talk a little bit about discretionary trusts and hopefully just some of the basic legal framework that results when we're using discretionary trusts. But as always, nothing is really all that useful unless we've got some practical application to the use of discretionary trusts. So Jordy, do you mind opening with some comments on the sort of the overview, and then maybe a quick demo on how you're implementing them, and then we're going to talk a little bit about the implications of it from a legal standpoint.
Sure. So just the idea that a discretionary trust, we use that term, it's typically a situation where you've got more than one person as a beneficiary, more than one beneficiary of a trust, and the trustee is granted discretion to pay out, to encroach on capital and income as they see fit among those beneficiaries. And so the key decisions that you have with a discretionary trust are the same key decisions you have with every trust where there's financial assets, so money or investments, et cetera. You got to think about beneficiaries, who those are going to be, the duration of the trust, the distributions out, the trustees, and the gift over at the end of the trust. Those are the 5 key elements of any financial trust. And for a discretionary trust, typically, and as I said, you beneficiaries, you got to have more than one beneficiary, or else it's not a discretionary trust. Typically, we see trusts for what we call pooled trusts. We're pooling a bunch of beneficiaries, and they're sharing in a pool of money, and the trustees are distributing it. And maybe I'll just show, if I can, just how we might use that typically. So I'm just probably sharing the wrong screen, so just give me 1 second. And this is how we go through the process, whether you use eState or not. We're talking about a group of beneficiaries. So it could be a group of main beneficiaries, named beneficiaries, for example. It could be a class, a pooled trust for all of my grandchildren, for example, okay? As long as there's more than one beneficiary, it's a discretionary, or it's a pooled trust, which is typically discretionary to allocate proceeds among the different beneficiaries. As an example, we might set up a discretionary trust for Jimmy. We would choose trust. That's what we're doing here. And in this case, we're talking about a pooled trust. We're talking about a discretionary trust, pooled trust for more than one beneficiary. We need more than one beneficiary. So we have Jimmy, but we might typically add, for example, his children and maybe even his spouse. So now the beneficiaries are Jimmy, his children, and his spouse. And then we might pick the trustee of that trust. Now, maybe it's Jimmy himself as the trustee. And so we could do that. That's not uncommon, and Ian and Susanna will talk about the choice of trustees there. The duration is going to be Jimmy's death. There's not going to be any mandatory payments. In other words, the distributions out of the trust are going to be discretionary, and that's really what Ian and Susanna are going to talk about. And then, of course, we're going to need to talk about the gift over. So what happens when Jimmy dies and the trust ends? Does it go to his children? Does he get the right to appoint the beneficiaries? We'll talk about, or Susanna and Ian will talk about the choice of gift over beneficiaries at the end of the trust, for example. And that's how you create a pooled trust or a discretionary trust, whether it's eState or anybody else. You got to think, well, who are the beneficiaries? Are we including other people as part of that? And then trustee duration, distributions, and gift over. So I'm going to turn it back to you, Ian, and Susanna.
All right, thanks, Jordy. So we're going to enhance these slides only because I ran out of time today to get myself more organized, to add some of the cases that we're going to reference in the next bit of the podcast. And so don't worry, once the uploaded slides will have the cases that we're going to cite. The starting point, though, with any discretionary trust is, and this is, it seems to me to be a really important point for solicitors to be managing with their clients. When someone either decides to do a discretionary trust or is in the middle of a discretionary trust, um, Susanna, let's just talk about at a high level the Fox and Fox sort of analysis and the kinds of things that generally the executor, the trustee, is expected to consider when exercising their discretion, because that's the starting point of anything. How these trusts work and how to value them and those sorts of things we're going to talk about today, or if not, we run out of time, we'll go into the next podcast. But the starting point always is, what does it mean when you're given broad discretion, and what is it going to be expected of the fiduciary when exercising that, fiduciary or fiduciaries when exercising that discretion? So Susanna, did you want to just make a preliminary comment about the exercise of discretion generally?
Yeah, and of course, the expectation, of course, is that since the trustee is a fiduciary, they're going to be acting in the best interests of the beneficiaries. And so we want to make sure that, we don't get criticized when we are acting as a trustee for doing things improperly, exercising our discretion improperly, for instance. And the cases, and certainly the Fox and Fox decision, talks about this concept of mala fides, which is, you can't take irrelevant considerations into consideration when you're trying to make a determination as to whether or not to, exercise your discretion in favor of one beneficiary over another. And so the key really is to make sure that we're not acting improperly, that we're not, considering things that shouldn't be taken into consideration, or being vindictive or acting outside of the scope of our fiduciary responsibilities.
So the other part of this, and I'm involved in this debate on lots of files where discretionary trusts are in place on the litigation side, but I always see it as sort of something that can be avoided, and that is this: the exercise of the discretion needs to be, in my view, and in the case of Fox versus Fox, which went to the Court of Appeal, talks a little bit about this too, but Ginsburg, which we'll put in the slides as well, started this whole debate in the 1800s, is that it needs to be documented. It's a judicious determination based on what Susanna says, mala fides, but it's a judicious determination. And if you're going to make a judicious determination, it typically needs to be documented in what is essentially a memo form that can be and should be available for production for the beneficiaries. So even when you get in a situation where you've got, and we're going to talk about discretionary trust, but even the exercise of discretion, when you're given the power to exercise discretion as a fiduciary, every time you exercise that meaningfully, that discretion. So for example, if it says income to go to, we set up a trust that provides for income for a beneficiary, a single beneficiary, and the amount of that income is to be at the discretion of the trustee, for example, even a simple scenario like that. Every time you send out an income payment, you don't necessarily have to have a memo as to why you calculated it. But if you're going to create a process where you're going to take the minimum amount and pay out the minimum amount on each occasion, it's probably worth the trustees documenting that decision. I have decided to only send out the minimum amount because of the fact that I think that the trust is going to run out of money or something like that, and I've come up with this judicious determination. I understand the beneficiary's circumstances and so on. And this is not something that, this is a standalone document that I create. I have my clients create when they're at the time and the point of exercising that discretion. And that becomes even more important when you get into discretionary trusts. All right. So we've talked now, Susanna, about the concept of exercising the discretion. Now let's talk about the impact of a discretionary trust and really where does that come in? And you'll often see this issue raised in circumstances where you've got a family law fight, where you might have a situation where a husband and wife are splitting up, and one of them, the wife, has an interest in a discretionary trust. and how do you manage that? And what are the circumstances surrounding that? And we're going to talk about later about how we value it. But this is where we can start with the discretionary trust. It's the choice of the trustees of these discretionary trusts. And as Jordan has identified, it can be, of course, as he said, that the person who's the recipient of it. It's just as we walk through the case law, we'll see that that choice can be problematic, because the question of control is an important element in actually calculating the value of a trust. So let's talk about, Susanna, just the choice of a trustee in a discretionary trust scenario. And we will just come back to Jordan's example where he's got various beneficiaries, in his case, the children, and you could put in grandchildren or you can put in the spouse. But in a family law fight, you'll often see a case where the trust is, and we'll use this as the example, the discretionary trust is set up whereby the husband and the wife and the children are all potential beneficiaries of a trust. So the choice of trustee can be paramount there. So maybe, Susanna, do you want to talk a little bit about how do we guide our clients in the choice of the trustee, and maybe what problems might arise with the specific choices?
Sure, Ian. Certainly, in a family trust arrangement like that, it makes sense that, if we're setting it up for the family and the next generation, that the parents would be the trustees. When we're looking at trustees in any situation, of course, we're looking at, the capacity of that individual, whether they are someone that would do well in that role. We're looking at the age of the trustee to make sure that if it's going to be a long trust, that there's going to be some longevity there. If it's a complicated, trust arrangement, that's going to need a lot of, expertise. Is this individual the right person for it? But when we're looking at it from a family trust perspective, and we're looking at, as you said, determining what the ultimate interest someone might have, or an entitlement they might have to a trust assets as a beneficiary, then the fact that a trustee is also a beneficiary may ultimately go to the issue of control. And that matters for the purposes of when we're trying to value someone's interest in a trust, and whether or not in a family law context, on the marriage breakdown, if it's going to be something that we're fighting over in terms of a proprietary interest. Does that beneficiary, who's also a trustee, have an interest in this trust that we can attach to for the purposes of, the NFP calculations, or for determining income for support and things like that? So, when we're setting these up, we're not necessarily always thinking about the things that can happen down in our dark world as litigators, but it is something that, we may want to consider canvassing with our clients, because it may ultimately affect things down the road that, we may not have necessarily anticipated.
Yeah, and that's the problem is that the anticipating a marriage breakdown and creating these plans is something that can often be overlooked, and everybody's happy and loving it, and so you create these discretionary trusts, but you don't see the nightmares ahead of you. So just in terms of the kind of core terms of the trust itself, the articles within the trust itself, you're often going to see in a discretionary trust, of course, a definition of trustee, that's to be expected. And then you're also going to look for, as Jordan has decided to describe, when does it come to an end? And if it does come to an end, how shall it be distributed? Susanna, are there other kind of core clauses that you consider to look to when you're making sure either the trust is there, or when you're analyzing the trust in respect of a contentious situation?
I think it really is going to depend
Jordan's
on.
Actually, sorry to interrupt you. Jordan's bringing up an illustration that might be where we should work from first. So
Perfect.
maybe Jordan, why don't you jump in? Thankfully.
Sure. This was the draft that got generated based on what we had done. We set up a trust for the residue for Jimmy, but it was a pooled trust. It was a discretionary trust with Jimmy as the trustee. And the reasons that we see discretionary trusts, there's the flexibility to spread money, not only among the primary beneficiary, Jimmy, but among his kids and his spouse. And that's typically done for some tax benefits. you can, you can sometimes in some circumstances sprinkle income and have it taxed at different rates. And so what we have is the appointment of the trustee. We have the beneficiaries being Jimmy. We picked his children rather than his issue. We did a more limited beneficiary, and we added the spouse. But whenever you add a spouse of a person as a beneficiary, it's important to consider, and it doesn't mean you have to do this, but that what happens if that spouse separates? I mean, is the key thing that Jimmy the key beneficiary, and his spouse is added as an adjunct, and only if they're not separated. So just consider that. By default, our drafting does exclude the spouse if they're separated from the main beneficiary. And then the next part is the duration, right? How long is this trust going to run for? Until Jimmy dies. And as you can see, this is a discretionary trust. So pay for the benefit of any of the so that's Jimmy, his kids, and his spouse. And it's discretionary. This is what Ian and Susanna are talking about there. We need to deal with accumulations, but that's a technical thing. But then we got both income and capital. And then we've got the idea of what happens at the end of the trust. So when Jimmy dies, that's the pooled fund distribution date. What are we doing with it? In this case, we were dividing it. I just picked the kids, divided among the kids. And this was a per capita, obviously, if it's children distribution. But then we also had the provision that what happens if Jimmy's not alive? Who do we want it to go to? Well, we want it to go to the same beneficiaries as if he had survived and then died. And so that's what we've done here. So that's just a very simple, what we call a pool trust. And it's a discretionary pool trust in essence.
Excellent. Thanks, Jordy. Actually, that was sort of the question I was going to ask Susanna to go through. So you have quite helpfully jumped in, and we will move on then. Now that we've got an understanding of the concept of discretion, the use of it, the terms that we're going to be looking to in terms of the vital terms of the trust itself. Let's talk a little bit, Susanna, if we may not get through all of this in this, but let's start the discussion anyway about the tension that can exist with regard to discretionary trusts and of course the world of family law, because that's really the area when we're drafting our wills, and of course when we're administering estates, that we want to be able to give our clients some good guidance on. We do need to anticipate marriage breakdown. We do it on many levels when we're drafting in any event. And so let's talk a little bit about that tension and some of the tension and some of the issues that come out of that tension between family law and trust law.
Yeah, I mean, the tension that you're referring to, Ian, is the one that, when we're talking about traditional trust law principles, we know, that a discretionary beneficiary does not necessarily have property rights. So it's just a discretion is going to be exercised in your favor, in which case they have an entitlement, but they don't have something that they can tangibly insist upon. That's why it's a discretionary beneficiary. And when we're looking at it from a traditional trust perspective, it's very different than when we turn to like a family law perspective, where when we're talking about valuing these interests or these entitlements, we're looking more at a fair share of family wealth kind of analysis. So even though as trust lawyers, we would say, well, a discretionary beneficiary has no property rights and ascribe no value to it, when we're in a family law context, it's very, very different. And unfortunately, we see the cases which are not really helpful in that regard, except to demonstrate that, sometimes we'll take extraneous considerations into effect or into account when we're trying to determine whether someone has an interest, and if so, what that value of that interest is, if we're going to have to actually quantify it.
Right, and so that comes back to the decision to add in the spouse to these discretionary trusts, big time, and it comes back to the decision as to who's going to be the executor. The trustee of the trust itself, because it's really comes down as simple as this. And we'll talk about some of the cases that say this so that we're not just talking broad strokes here, but the concept really comes out of this. The value in a family law contentious situation of the interest in the trust of the husband or the wife, depending on whose trust, on which side it's falling in, is it almost can be described as this. It's either zero, which we as trust lawyers kind of come to that because we think that's actually the right answer, or it's some percentage of it. And so how do you come up with that calculation? And so there's two streams of cases, one stream that says it's zero and one stream that says, no, it's more complicated than that. And so let's talk about those two streams so that we can get a better handle on it, because the bottom line is the advice we need to give, I'd like to give my clients in these situations is that it is a crapshoot. And it may not be zero. So be very careful about how you want to set up these arrangements. Be prepared for it to possibly not be zero, but that it might be a proportionate share of the beneficiaries that have been identified. And so in Jordan's example, it could be that the trust value is allocated on the basis of the number of beneficiaries in the trust itself. So Susanna, let's talk a little bit, let's get a little granular on this, because these broad concepts are only developed and tested through the cases.
Sure. Yeah, and like when we talk about it could be zero value to it, or it could be some proportionate entitlement to the entire amount at play. What we're talking about is the fact that, you know, when we start with traditional trust principles, if you are a discretionary beneficiary, you have no control, you have no right to demand anything. And so when you're in that kind of a situation, control becomes a very important thing, because it's the trustee who controls who gets what. And if a beneficiary is simply a discretionary beneficiary, then they can't control anything. But if that beneficiary is also a co-trustee, or if that beneficiary has some kind of persuasion with the trustees, then suddenly control matters. And control then can have value in the sense that you're going north of that zero value for that discretionary interest, because suddenly if you can control how much you're going to get, then it's going to be more valuable to you and ultimately more valuable in any calculation. And so, you know, we start when we talk about these kinds of things with the 2016 decision of Tremblay versus Tremblay, where the court says, okay, when we're talking about a discretionary interest, there is no value to it. It's simply an expectancy. And so you can't put a value on an expectation unless and until there's something more solidified behind it, like some kind of control, so that that expectancy becomes more likely and therefore more valuable, and something that we can start to ascribe a value to. And so the concept really is one of meaningful control. Can that beneficiary have some control over the process so that we know that they're definitely going to get something, or that they're not? And that becomes the real issue that the cases are sort of delving into when you're trying to determine if that's the case.
So how does it, Susanna? So control is a broad statement, and we've identified where the obvious control could come from it being a trustee and so forth. But what are some of the sort of the factors that the court will consider when analyzing the degree of control in the context of, and it's certainly the Tremblay decision started this, but there's other cases that we'll talk about later that helped develop this. But Tremblay really is kind of a great benchmark anyway. So Susanna, what are some of the factors?
So we start with the fact that it's really a contextual analysis, and it's always going to be case by case. And so this analysis, of course, gets informed by the nature of the relationship between the parties, and then this concept of fairness. So when the court's looking at factors, it's looking at, for instance, you know, is there any evidence as to the founding intent of the trust? Was the trust actually created to effectively allow control to the beneficiary? Or was it created for exactly the opposite reason, so that they have no control over any of the distributions that are being made? So that's one of the factors that the court's going to look at. It's going to also look at the composition of the trustees. And we've talked about that already, and whether or not the beneficiary themselves is a co-trustee. And as part and parcel of that, if they are a trustee, if there's any requirement, including this right to a veto, that the beneficiary be part of a trustee's decision, that's going to go a long way towards demonstrating that there is going to be a degree of control if we actually have to, run our decisions by the beneficiary before distributions are made. So those are some of them. There's a history of past trustee actions. So, if distributions were made in the past and we can demonstrate that this has happened and that there's almost an expectation that it's going to happen again. So whether there's direct or indirect control, the history and the transactions in the past are going to inform a court as to whether or not maybe we're going from completely discretionary beneficiary to someone who actually does get to control the process. Another really important thing is the power of the beneficiary, if they're going to be entitled to remove trustees or to appoint different trustees, because that clearly will speak to the fact that they can maneuver things behind the scenes if they don't like the decisions of the existing trustees. And then the last factor that was sort of set out in Tremblay was, the nature of the relationship of the beneficiary to the trustees, because of course that's going to have some possible persuasive entitlements if they're very close and it's a family kind of situation, as opposed to a third-party trustee who's running a family trust. So depending on each of those kinds of considerations, the court is going to be able to determine, or we're going to be able to tell our clients that it's possible that someone's going to ultimately say that this beneficiary is not a completely discretionary beneficiary, but actually someone who may have some control over the process at the end of the day.
Well, that's fantastic, Susanna. Thanks. That's very helpful. So I think we are going to run out of time, and that's fine. We're going to do a part 2 next week, and then the slides will be updated with the cases, because we do want to talk a little bit about the Supreme Court of Canada's analyzed this question, and also talk about some of the tangible evidence that you look to develop these factors. What kind of evidence? Financial statements, as I talked about earlier, the possibility of notes, trustee minutes, discretionary decision memorandums. Those sorts of things are all going to be factors to look to. So we've got the parameters, and we're going to talk a little bit about what else some of the other cases have talked about, and then lastly talk about what is the actual tangible granular evidence that the courts look to help develop these answers. So Jordy, over to you to wind up, and we'll be back next week to continue this discussion.
Well, thanks, Susanna and Ian, so much for helping us through discretionary trust, which we see certainly we see it more in different jurisdictions. We see it in Ontario, and we see it from for creditor proofing and other reasons. So thanks. And I just want to remind everybody that every Tuesday at 12:30, I am live with a webinar for e-state users. It's 15 minutes of professionalism that you get, plus some substantive as well. And this week coming up, we're doing beneficiary designations in e-state planner, how to do RSP designations, TFSA, life insurance. So we'll show you the ins and outs of that, and some tips and ways of making that work better for you. So thanks everyone again for being here. Thanks again, Ian and Susanna, and we'll see you again next week. Bye-bye.
Thank you, Judy. Thanks, Ian. Thanks,
Bye-bye.
everyone. Bye now.